regimes that you're dealing with. Now, let me give you a couple examples. The two of the statutes, we don't need to see that, two of the statutes that have been most prolific recently are the Foreign Corrupt Practices Act and the one at the bottom, the Foreign Investment and National Security Act, known as FINSA. Foreign Investment, National Security Act is not that well known. It basically has to do with any investment by a foreign person in a U.S. business, not real estate, not a hard asset, in a U.S. operating business that is involved in any activity that affects the infrastructure of the United States in a way that could affect adversely or compromise a national security aspect of the United States. Now, just the definitions alone, there are hundreds of pages of regulations that deal with this, but let me give you two examples. One example, and both involving Chinese companies. There was the acquisition of Smithfield, which is a large manufacturer of pork and food products that occurred several years ago by a Chinese holding company. It had to go through a particular clearance of the transaction. It was approved, but it is now being critiqued by Congress as having compromised regulations of our food products, and so Congress now is looking at that. The one that's most is drawn the most attention is a case called the Rawls case, and in this case, a Chinese holding company went in and bought some wind farms in Oregon, and the transaction, they did not seek pre-approval of the transaction. They invested a lot of money into these wind farms, and then CFIUS, the organization that oversees FINSA, came in after the fact, in a sense, and said, no, you can't do the transaction. The president issued an order and said you must divest yourself of all your investments and sell off the assets. They have filed lawsuits. The lawsuits are still going on. Foreign Corrupt Practices Act. I attended one of these workshops on international M&A a year ago, and the #1 topic in that two-day seminar was Foreign Corrupt Practices Act. It is literally the hottest topic in international cross-border business today. The regulatory regimes are dramatically different. The U.S. statute is the most complex. There are others. UK has a statute. Canada has a statute. But when you go into the other countries, particularly the emerging countries, there are really very limited regulatory regimes. And a great risk factor going into another country, whether it's China, Russia, India, I've had experiences in all these jurisdictions, is you can go in and not buy the company, you can buy the assets. And if you can't demonstrate that you have done proper due diligence on every aspect of that company's business, every aspect of their dealings with foreign officials, you can be held liable for actions that that company undertook before the transaction was completed. So these are, it's a very complex area. I will say, sort of, I'm not have anything to do with the Department of Commerce in Georgia, but I was looking at a chart recently outside of New York, California, and Texas. Georgia had the most direct investments from China in 2014, and North Carolina in the whole United States. So there is a lot of activity in this area, and I guess my final point is you can always find evidence of these things in the news. Here's today's Wall Street Journal, and the EU Commission has now charged Google with antitrust violations, and they will be penalized billions of dollars of euros over the next period of years, and probably some fortunate law firm will be paid several $100 million to try to defend it. But I would imagine that Google will, to a certain extent, will get one out of Europe in a sense, because they're going to now be in years and years of debates with the European Commission. So that's just an example of how difficult these issues are and why you have to do the detailed due diligence from every aspect, not just the business, the economics, but the regulatory regimes and the cultural aspects of it as well.
Thank you, Phil. Yeah, I mean, looking at this list, you would conclude that the US is probably one of the more difficult markets in which you can do business, right? And how many lawyers in the room? Only one? Two? One of the biggest fears inbound investors have is the cost of litigation in the United States. And it's such a big, scary, unhandleable kind of situation. And invariably, a lot of them want to depend on alternatives like mediation, arbitration, rather than get stuck with the legal system. Talking about that, recently there was a very, very large transaction involving Indian group. Indian groups have been very active in acquiring US assets. Some of the large acquisitions that have taken place recently have been the acquisition of Novelis, the largest aluminum can producer, the acquisition of Columbia Chemicals, one of the large carbon black producers, and more recently, Indian group called Apollo Tires, went into a transaction with Cooper Tires, and they were to acquire Cooper for $2.5 billion. And that whole transaction ended up very badly for both companies. And all because of two things. One, a joint venture of Cooper in China, right? That triggered they basically upset the whole transaction. And this joint venture was a company called Cooper Chengshan Tire. And they were so upset that they went to Standard Chartered, who was one of the financiers of the transaction for Apollo, and tried to put pressure on Standard Chartered to pull out of the transaction, pull out their funding. In addition, they stopped manufacturing any Cooper branded products in China. And then they stopped giving any information to Cooper about the JV, so that Cooper had no way of producing the closing documents for the transaction. So it was one bloody mess. And then Chengshan put an advertisement in the Wall Street Journal which said, who can guarantee the success of integration between Chinese culture and Indian culture? And that transaction died. And now, of course, there are lots of lawsuits up and down because there was a $112.5 billion breakup. Right? And of course, a lot of other damages. So it is a very complex world, and trying to figure out which part can upset the whole apple cart is itself a challenge. We spoke a little bit about due diligence. What do you all think is the real value of informal due diligence? You do a lot of formal due diligence, but informal. Do you see that as an important mechanism for getting a sense of is everything okay or something stinks or what?
I think I hit it on the head when you said there is nothing called enough due diligence. So, and it never ends. And it's formal, it's informal, it's never enough.
Linger forever. Absolutely, and quite honestly, I usually put more weightage on informal due diligence than a formal diligence, because when you do diligence, for a company like us or Portman or others, we would hire outside help. So we would hire some tax accounting firm to help us with the tax due diligence. We'll have a legal firm do the legal due diligence. So they do their job very good and everything else. So I always put, again, a lot of weightage on informal. So one of the things I do whenever I go to a new country, I usually go a week or so before my due diligence team, and not to meet any customers or anything. I roam around the city. literally I just go around, try to get a sense of what the culture is, what the people are thinking. I would sit in a coffee shop, restaurant, just try to understand what's going on around you, right? Because if you're trying to sell, again, a consumer product, or you're selling financial product, whatever the case may be, a lot of that you learn a lot when you're just looking at doing a lot of informal, talking to people that either you know through your network, through your colleagues, call them up, have a chat with them, understand what's going on. As I said, from me, I always put a lot of weightage on that because I find more information during informal due diligence than a formal, because formal diligence usually, for lack of a better word, it's a stage. Everybody, you ask documents, they produce documents, you look at it, you go about signing off, right? You don't find things that typically you find in informal than you find in formal.
Sorry, just a quick one. Our typical time frame for due diligence in a country is about 10 months on average, before we would really start looking at doing a deal out there. And it's a lot cheaper to put two people on the ground and have them go back and forth and talk to people and go through your legal relationships and your banks and your other contacts than to make an investment and then try and get it right after that. So our typical average time frame is around 10 months.
And just to add to what Shahid was saying is, for example, I just helped a client close an acquisition that they were doing in India. And in the due diligence, the CFO basically was trying to use us for accounting and a law firm to do the legal due diligence. But as Shahid mentioned, the informal due diligence was the key thing. And what I just suggested to him that he should go out to India, spend about 5 to 10 days, go meet different people in a similar business fashion, and understand that if they're going to do business in India, what is the model in India? How they're going to work in India? And he took up that suggestion, he went there, and after coming back, I think so he was more keen on acquiring and moving forward with the acquisition of the entity. But that's very, very important that you should do informal due diligence. Go to the country, understand the culture, the language, the people, because that's where you will really understand that how you're going to work in that country and do business in that country.
If we could go back on the slides to one more back, M&A due diligence. Let me make a couple of technical comments that tie into the comments that the panelists have made. First of all, in a transaction, there's an issue, when do you do due diligence? They've just done a wonderful job of talking about what a sophisticated company does as far as informal due diligence. That's particularly important in a private transaction when there's not public information available about the company. In a public transaction, there's going to be a lot of due diligence done through the stock exchanges and through the information that's available formally. But the timing of a transaction cross-border is triggered by typically, now there are exceptions, countries that do things more on an informal basis, but typically you'll have some form of legal document. It'll either be a memorandum of understanding, a letter of intent. It will not be a full-blown contract. There's lots of nuances about whether those documents are binding or not binding. They always have confidentiality agreements involved with them. But they're also important because they trigger certain filing things, like filing the Hart-Scott-Rodino under the Sherman Act, or whether you can go to CFIUS and get an informal review of a proposed transaction. You can't do that on a handshake. You have to have some document in place that suggests that the transaction is going to go forward. Here's an issue that's very catches a lot of people off guard, which is duties to disclose and investigate. There is no duty on a seller, per se, in the United States to disclose information, certainly not adverse information. That information must be drawn out of the seller through the due diligence and through the contract documents. And so the burden is the expression caveat emptor, buyer beware. The burden is on the buyer to do that due diligence. Here's an odd twist, but a really difficult one, and then we'll go to the litigation component. If you are a director or senior officer of a company and you come into the US and you do an acquisition and you don't do due diligence, this could also apply to a US company buying a business abroad, you can be held liable even perhaps personally liable for not exercising your duties of a reasonable businessman to oversee the due diligence process. That, I know that sounds, like that's not the real world, but it is the real world, particularly in the U.S., because the U.S. is so litigious. Now, one of the points you made about litigation. Most of my foreign clients say the same thing. We hate the U.S. as far as doing business in it because you litigate over everything. And you also, what they don't like is you can't do anything in the U.S. without a 100-page document, which means you have to hire some lawyer who's going to charge you a lot of money to do the 100-page document. I won't dispute that. This country is overly detailed when it comes to that. But the advantage to that is there's some certainty of knowing what you're dealing with. And the court system, in my unbiased opinion, is the best, period, throughout the world. Now, because foreign countries aren't comfortable with the U.S. legal system and litigation, if you're doing an acquisition, particularly abroad, what most experienced practitioners will tell you is you provide that any litigation is going to be undertaken in a neutral setting, such as arbitration before the Swiss Arbitration Tribunal. I just represented a client about 5 years ago that made a $250 million investment in the citrus industry in Brazil. We provided that in the documents, and it turned out that there was fraud involved, and we went through 3 years of negotiations. And had we not provided that, the client would have lost their entire investment, because what you later find out, no Brazilians in the room, is that basically the judicial system, jurisprudence system, is you can buy it in each different state, Sao Paulo or whatever, and those judges are basically, there is no legal precedent. They don't have the same legal system. It's a civil system, not the common law system. And so had we not done that, the client probably would have lost the entire investment. As it was, after a year of arbitration in Zurich, the client got all their money back plus a computed return on the investment. So the way you provide for dispute resolution can be also critically important, as you pointed out.
So, Solomon, in that case, normally international arbitration is not binding locally. So are you able to enforce that in Brazil, basically?
You get the clients, if you negotiate that it's binding arbitration,
Right.
and a sophisticated party is represented by counsel, it is binding.
But if they don't comply, what's your recourse then? So the arbitration is already in your favor, right?
Right.
And if the client doesn't comply, how do you enforce it?
You have to take, it's a very sophisticated question, you then have to take the ruling from the tribunal and you have to domesticate it in the country.
And that's the issue.
And then you're stuck in the other country's legal system, which will take forever. Yeah. So, yeah, these are, I think, some of the real tricky situations that you come across. The other, of course, was, when you say real estate in India, the first thing that pops up in your mind is, hey, is the mafia running it, right? How much of it is illegal? Are the titles clear? Whole lot of confusion. But it's not just real estate, it applies to everything else, which is, I think Rajesh was mentioning, what is the cost of non-compliance, right? So if, for example, your tax filing was late, or your social security type called provident fund filing was late, or some money didn't get deposited, what are the consequences? Now, and I would like some of you to address that, because one of the biggest fears large multinationals have is what's happening in my subsidiary or in my acquired company. Are they doing something which could get caught under the Foreign Corrupt Practices Act or something similar, which would be a major embarrassment for the brand, even if it is small in terms of actual dollar amounts. So from both a due diligence perspective as well as from I think especially for the two of you, from an operating perspective, what is it that you all do to make sure that you stay on the right side of some of these situations?
I think to that point, Madhu, I will say one thing. I don't know how many of you guys have heard about the Vodafone case. The
Yeah,
Vodafone case,
Vodafone
that was a
and-
significant litigation that, tax authorities in India were chasing. It was basically an indirect transfer of Vodafone. They were basically having two entities outside India. They transferred the shares, and the Indian entity was a part of the whole transaction, and the tax authorities in India started chasing Vodafone, saying that the indirect transfer of the shares had the Indian shares in them. Therefore, there's a capital gains exposure, and because of the capital gains, you have to pay close to about $2 billion or some dollars, to the tax authorities. That was litigated all the way to the Supreme Court, and it's still on negotiation stage right now with the arbitration. It's still not decided at this point. But fortunately, the India budget that came out this year, the government is trying to make it easy for foreign companies to do any kind of transaction, and they have proposed that let's look at the substantial value of the assets that are getting transferred in India, and then they're trying to come up with clarity on the regulations so that any transfer that happens, there's no capital gains exposure, and nothing like Vodafone could be imposed again by the tax authorities in India. So just to mitigate that, that's why whenever any transaction happens or you're acquiring a company, make sure that you do your proper due diligence and look at the local tax laws and the tax treaty of the country. Because if you don't do that, the tax authorities are going to chase you, and you will get into litigation and some kind of a significant penalties, and that you won't avoid at the end of the day.
That was a very specific case where the court system actually ruled in favor of Vodafone, and then the government was all very upset, saying that, hey, this is tax revenue due to us, and just because of language ambiguities, Vodafone is escaping. So they went and created a law with retrospective effect. They changed the law so that it could be implemented against Vodafone, and that created a huge amount of drama in the country. But I was referring, I was not so much referring to aggressive tax regimes, because every tax regime, whether it is the US, Germany, UK, India, everybody is very aggressive because they want their collection. They don't want anything to happen under their nose where they don't get the collection and some other country gets it. So everybody is aggressive there. And so that's fine. But I was talking about more in terms of graft, cash payments, those kind of things, which, especially in some countries, you took the example of Brazil. When I go to Brazil, people tell me, hey, you know what, you have to think about the Brazilian cost of doing business. So the first time I didn't know what it was, so I said, what's that? They said, hey, if you want your goods to come out of the customs yard, you have to pay. If you want your goods to be transported, you have to pay the invoice, but you also have to pay after the invoice. And if this has to happen, you have to pay. So they said, look, plan for whatever, 20-30% of your cost as the Brazilian cost of doing business. Now in India also it's the same thing. And that's why I picked up real estate, not to put you in a spot, but because it's an important thing in most of these markets where titles are sometimes sold to multiple parties. The regulating authority needs to be bribed to make something kosher, all kinds of stuff. So any experiences there?
I think the myth of that is bigger than what the reality is.
Okay.
I think there's a process that you have to go through. From our point of view, if we hit something like that, we don't go ahead.
Drop the project.
That's it, we drop the project. So life is too short, and you want to do things that you can live with, and you can sleep at night, and it's really as simple as that. But I will tell you, in India right now, we have about a 5.5 million square feet residential portfolio that we are constructing. We've never had an issue. We've basically underwritten our deals in a way that if we would have finished them in 5 years, we assume it would be in 7 years. And we've just built that time in, and we've generally been about 6 years, and we've run into roadblocks, and we've sorted through them, and we've never had an issue. And I think you'll find in certain countries that people realize that they cannot ask for things and get away with it. Mm-hmm. And so we find in a lot of cases, we hear stories of this, that in-country asks are greater than asks for people who are coming from the outside.
Outside.
But that's a policy. So if we run into a roadblock, so if we buy a piece of land, we would buy it from a well-established player who's already sorted it out, who's got the land for a period of time and stuff like that.
So does this go back to finding a right partner?
Yeah, absolutely. Who do you do business with from our point of view
Yeah.
is the most important thing in terms of going offshore to any country.
So the due diligence of the partner.
Yes.
Madhu, if I can add, and I completely agree with what you just said. I think each country, when you're doing, whether it's informal, formal, due diligence, or business case, you have to factor in that time. If you think you can do something in 5 years, add 7. Because all it is it's basically, it's going to take, it's the cost of doing business in that country. And you can always do the right way, it's just going to take you time. Even in our case where we don't build, any real estate or anything like that, those things exist everywhere, whether from electrician to cable guy to builders or whatnot. Again, it's a cost of doing business. You have to be disciplined. You have to put a right governance. And like he said, if it comes to it, you should be able to walk away. You should be prepared to walk away.
I do want to make one ten.
Yeah, and that's what I think.
Sorry.
We'll switch to, maybe we'll pick up some questions from the group. And yeah.
Excellent presentation. I'm pretty greedy. I have 2 questions. One
Sure.
concerning law. How does the FATCA, the Foreign Contract Compliance Act, impact the cross-border M&A activities as well as the Asian subsidiaries of U.S. companies and the U.S. subsidiaries of Asian companies operating here? And then on the flip side, how does it, in addition to the documentation, what are the negative impact?
I think you're referring to FATCA?
FATCA, yes.
Yeah, that's the,
Foreign Account Tax Compliance Act.
Yeah.
That was introduced in 2010.
yeah.
That is a pretty, that's something that whenever you are acquiring a company or doing a due diligence, and FATCA is more relevant for basically US companies that are operating in India, which have a foreign financial FFIs.
Okay.
So whenever you're acquiring a company, whether it's outbound or inbound, you have to do a due diligence and understand
Both sides,
whether
right?
that both sides. Whether that foreign company, if that's acquiring a company in the US, whether the foreign company has any kind of a company or they're into any foreign financial institution definition.
So it's more
They fall under
documentation.
the 1446 regulation of FATCA, that are they purely doing some kind of finance transaction? They're not doing any operating business or manufacturing business. They're purely taking money and giving it
Marking
to
it for
tax
tax.
subsidiaries or related party. Then you have to do that due diligence and make sure that you do that. And then if they fall under 1446, then you
Can you also address AML in the same breath?
Yeah, it's basically, let's take an example about, if a bank, is, if you're doing a FATCA, and a bank, you go to, say, India and you want to open up a bank account. The bank in India is going to ask you for every specific document, KYC, AML document, that what are you, what kind of business are you into the US? What is your transaction and what business you do? So they are going to go into detail and get your AML and KYC information before they open a bank account in India.
AML is now across the world.
Across, yeah.
So it's highly regulated and highly exercised.
That was a great presentation. I learned a lot. So my work is in cross-cultural competency training, and I was thrilled to hear almost everyone in the panel address that as an important issue. But as most of you probably know, there is a psychometric assessment that can measure your intercultural intelligence called the IDI. And disturbingly, the results on that for even senior leaders who have a lot of travel exposure are usually not that high. So I wondered what your organizations were doing to prepare your workforce for all of these cross-border M&As.
That's a great question. Yeah.
So we usually all go through that test. No, so there are trainings that are put in place, both in US as well as the country we are doing business in, to make sure that people understand the culture nuances, how to communicate to the people, to the extent to when you sit down on a dinner table, how you eat, right? I mean, all the way from very basic things that we take it for granted here to more sophisticated cultural differences. So there are usually training in place, and we go make sure all our people are trained on that.
Sorry. go ahead.
You're good, Amrish.
So yeah, it's a question for you, Madhu. Just, in the M&A space, is it really a demand-oriented business for you, or are you at your desk sort of putting together the pieces of a puzzle in a certain industry and then bringing that proposal to both parties and saying, hey, there could be a fit here and to your product line, and you should really consider an acquisition? I mean, how do you go about it?
In cross-border?
Sure.
Okay, I'm going to take cross-border as an example. What happens is that these transactions can either be initiated by the seller who wants an exit, or from a buyer who wants to grow through an acquisition. So typically there is a starting point. Very rarely do we go and adventure to put ideas into people's head unless we are part of their strategic thinking to look at new directions. So it's initiated with one. And a lot of times buyers or sellers are very clear about who they don't want. So like for example, we've had American companies selling assets in India who say, hey, we don't want to sell to an Indian group. Right? Because of whatever reasons, transaction complexity, pricing issues, the strength of negotiation with local players. So they will say, okay, we think our asset is very valuable to a European player who wants entry, so focus on Europe. So that kind of guidelines.
Sure.
Yeah.
Great presentation. Myself have worked on a few Chinese overseas direct investment to the US, so can relate to a lot of the things and perspectives you share from legal side, accounting side, and tax side. But I do have a question specifically for Ambrish, because Portman Holdings has a great presence in Shanghai. But as everybody has observed, the real estate market in China faces some very unique challenges. They're from the top of the development going through a slow growth period due to the new leadership of the President Xi Jinping's different reform policies.
Yeah.
Also, the ownership in China of land is so different.
Sure.
So it's not privately owned land, it's always, owned by government.
Yeah.
You only buy the right to use the land for a period of time.
Yeah.
So I wonder, as a American property management development or investment company, how do you face those challenges or differences in Chinese real estate market, and what's your strategy in this new era of leadership?
Sure.
Thank you.
That's a great question. Real estate markets always go in cycles, and there's always time periods when they are down and when they are very buoyant. So China, from a general, so Beijing and Shanghai, I think are in a very different bucket, but generally in China there's a slowdown right now.
Yes.
And we don't know how long that slowdown will last. So basically for the last 2 years, we've not been investing in China. But that's no different to what happened in the US. So between 2007 and 2012, we made no investments in the US. So it's really part of being in the business, and these are really long-term cycles. And so when the market slows down, we stop investing. Hopefully we don't get caught in the slowdown, but we've been caught in the slowdown as well. So that's, I hope that answers the first part of your question.
Yes, got it.
I think on the ground leases in China, if the ground leases were selective only to non-Chinese players, there would be an issue. But because every developer in China can only access a 50-year ground lease, that means that that's the rule of the land.
Mm-hmm.
And so it's a non-factor. It's not a factor at all.
Wow.
I'm going to take one last question before we talk about a little case study here.
So this isn't really, this is challenges, but it's not really mergers and acquisitions. So from a legal standpoint, one of the barriers of doing business here in the United States versus overseas is obviously product liability. So product liability is the percentage is astronomical here versus overseas. So as a U.S. manufacturer, you have insurance overseas, but it's only good in U.S. courts. So how do you think that it's like a barrier? Is it something that a U.S. company should be carrying additional insurance? How often do you see product liability issues in India or China or overseas?
You're talking about how do you assess the product liability risks in other countries if you're a U.S. business? Product liability has two parts to it. One is the regulatory regime. So there, my answer would be that you have to hire specialists who understand that, perhaps in the country you're dealing with, perhaps a huge law firm that has offices in that country. The product liability also, if you look at the United States, has a lot to do with litigation and case law. And that's where you get into the difference between common law and civil law regimes. Common law regimes, as in the US, has a lot to do with case precedent, and it makes it difficult to evaluate because you have to understand what the progression in the courts have been with regard to product liability. In a civil regime, it's different because they don't rely on case law per se. It all has to do with the interpretation of the statutes. So in a way, you could almost say that trying to evaluate product liability in another country that has a civil law regime might be in some respects easier because you don't have to worry about case law. But it's definitely something you would have to have local experts to help you assess.
The two recent plane crashes, MH370 and Germanwings, are a great example that will answer that question for you. But basically, a life in the United States under the US court system is worth a heck of a lot more than anywhere in the world, right? And it's very, very obvious, unfair but very obvious in these two cases especially. So with that, I'm going to ask May to maybe spend a couple of minutes to talk about a very interesting case study that involves the acquisition of Nanfu by Duracell. And we have a case study and a paper that we've written on this subject to talk about, which looks at all the integration challenges, where a company, a US company buying a Chinese company, somebody was considered low cost, the culture getting completely changed because of this acquisition. And I think there's a slide here.
Yes, after this.
Okay.
Can
Yeah,
you
May,
go
you
on with
want
the
to
slide?
talk about that?
Afterwards, yes. After this?
Yeah, there's
Okay.
one before. Yep.
So anyway, I'll take 2 minutes. We have this flyer, and Nanfu is so well informed.